Okay, so mabuhay. Welcome to our module 4 sa legal aspects in hospitality and tourism industry. So last time we talked about laws, partnership, citizenship, and etc. So last time we talked about partnership. So additional information lamang according to article or art of 1772. Ang lahat po sa partnership kapag meron tayong kapital na 3,000 pesos or more sa property, kailangan po mag-a-appear po siya sa public instrument natin na kailangan recorded po ito sa Office of Securities Exchange Commission or the OSEC. Ang hindi makapag-comply po sa pagbibigay ng information na ito, magkakaroon siya ng proceeding paragraph na kung saan makaka-apekto po ito sa liability ng partnership and members ng third person ng isang negosyo. Again, random lang yun so additional pala, not random, additional info lang siya. So today, let's talk about the corporation. So, corporation under Sec 2 of Batas Pambansa of 68, otherwise known as the Corporation Code of the Philippines. Ang korporasyon po or corporation ay dinefine bilang isang artificial being created ng operational law. Having the right of succession at saka ng kapangyarihan, it actually attributes and properties expressively authorized by law or incident to its existence. Base sa definition, di ba, meron tayo dyan na corporation is artificial being dahil because of the law. It is also created by operation law and it has the power of succession. It has the power of attributes, properties excessively authorized by law or incident to reto. So, ayun lang po yung mga ibang characteristic ng corporation. So, based on the definition provided ng batas, it can be deducted that corporation form of business has the following attributes. So, it is, yun nga, yan po yung mga unang slide natin, yung apat po na yan. Kagaya nga ng pag-aral natin, ng artificial being, ibig sabihin lang po nito ay function siya ng batas na kung saan gumagawa ito ng mga tao sa isang korporasyon o kumukuha siya ng tao sa loob para makabuo ng isang korporasyon. By operation law or sa operation law natin, nagkakaroon tayo or it becomes being with the attributes of an individual na meron siyang fully or full kapasidad na mag-enter ng isang contractual relations. Ibig sabihin po nito, kailangan yung taong papasok sa isang corporation, you are equipped, meron ka dapat mga liabilities, assets. It is actually legal or juridical person with the personality separate and distinct from its individual members. Kasi guys, sa korporasyon, hindi po kayo kikilalanin bilang kayo as shareholder or investors. But, makikilala kayo bilang isang korporasyon. Like for example, San Miguel Corporation. But the people behind that corporation, hindi po natin siya separated po siya sa corporation, yung identity nyo as investors. So, it actually created a flaw, kagaya sa pangalawa dyan. Meaning, sa kabilang banda, it actually pertains sa juridical existence of corporation na kung saan dependent po on the consent or grant ng mga sovereign po natin. From strict legal point of view, a corporation cannot come into being by mere consent of the parties. There must be law granting. So, ibig sabihin po nito, pag nag-grant po kayo, it forms the primary franchise of the corporation. Okay? So, it must be given emphasis sa mga underlying contract among individuals forming the corporation upon which the state grant may be conferred. Ibig sabihin po nito, kailangan alam po, for example, mayroon ka bang mga pending cases, mayroon ka bang mga lost business, bankruptcy, whatsoever, para po ma-assess natin if capable po kayong pumasok sa isang korporasyon. So, another important dito is yung the power of succession and yung mga attributes property authorized by law or incident to reto. Isang banda po ito na importante na attribute sa isang korporasyon, sa isang negosyo, yung right of succession. Ibig sabihin lang po nito, pinag-uusapan po dito yung capacity ng continuous existence despite sa death or replacement ng isang shareholders or member. Kung namatay siya or kailangan siyang palitan ng mga anak, kapatid, and whatsoever for some legal reasons. For it has a personality separate and distinct from those who are compose it. Yung strong legal personality of corporation, meron po siya or is an attribute that has made it most attractive sa mga businessmen when compared to other media. Again, so kailangan po capable po siya, and of course mag-undergo po tayo ng ethical and legal processes when separating kapag may namatay, separations, or what do you call this? Replacement. Okay? So, we actually have the advantage, or the corporate has actually advantage among other business types or other medias. So, the following are the advantage of corporate or corporation sa isang negosyo. So, we have the strong legal personality, the limited liability to investors, the pre-transferability of units of investment, and centralized management. So, when we say strong legal personality, the corporation actually has the legal capacity to act and contract as distinct unit in its own name. It has continuity of existence. Ibig sabihin lamang po nito, as distinguished from partnership, mayroon siyang strong legal personality na magkaroon ng separate and distinct personality from the members composing it. Unaffected po dito ang pagkamatay, pagre-resign, insolvency of any of its stockholders or members. Ibig sabihin po nito, like for example, sa isang korporasyon po, pag dinimanda po tayo, hindi ka po pwedeng idemanda ng ikaw mismo as a person or as a stakeholder, investors. Bagkus, i-demanda po mismo yung korporasyon na meron kayo. Kaya kadalasan, napapasara po ang mga negosyo na ang media niya ay isang corporation. A corporation actually has also limited liability to investors. Again, one of the advantage of corporate from form of business organization is limitations of investors' liability to amount of the investment. Ibig sabihin po nito, pinipictures po nito yung flow sa legal theory that a corporate entity is separate from distinct from its stake or share or stockholders. So again, ibig sabihin lamang po nito, iba po yung account na may kita, or for example, iba po yung yung legal theory ng korporasyon sa mismong mga stockholder po na meron ang isang negosyo. And also, it has transferability of units of investment. So, in corporate setting, as a general rule, the shares of the stock can be transferred without the consent of other stakeholders. So, hindi mo siya kailangan ipa-approve. So, mas easy, mas madali kung ipapatransfer mo siya. Like, for example, gusto mo nang ayaw mo na mag-invest doon. So, ibibenta mo yung share mo, yung stock mo doon sa isang korporasyon na yon without asking for the approval of other business stockholder na meron kayo. This actually would assure investors of a ready mechanism to dispose of their investments when their personal or financial situation may require it, and therefore yung mga places more liquidity in the corporate setting and would better encourage investors to channel their investments through corporate vehicles. And also, when we say advantage sa corporation, it has centralized management, meaning the corporation management is centralized in the board of directors. Ang shareholders, hindi po sila or they are not agents of the corporation. Bagkus, they can actually bind the corporation. Unlike sa partnership setting na kung saan yung mga member, meron siyang bind in the corporation or sa meron siyang bind sa partnership even without the knowledge of the other partners. Ibig sabihin lang nito, in legal relationship, ang korporasyon presents more stable siya and efficient system. It has efficient system of governance and dealing with third parties. Dahil nga 'di ba, yung mga management nila or mga prerogatives natin or prerogatives are centralized in board of directors. Okay? So let's talk about naman the disadvantage of the corporate form. Okay, so first, another advantage na ay yung mga registered or association, kailangan nyo rin siyang malaman. So kindly read na lang doon. So let's talk about the disadvantage of corporate form. So first, complicated and costly information maintenance, lack of personal element, abuse of corporate management, limited liability, hits innocent businesses or victims or double taxation. Kasi nga, isang malaking corporation kayo, ibig sabihin, mas malaki ang tax. And of course, yung mga tao ng tatrabaho doon, sometimes, they are the victims of yung mga legal aspects natin or mga benefits and privileges na meron sa isang negosyo. So, in corporation kasi, the control and management belong to the board of directors. Unlike sa sole proprietorship, where the owner has sole command of the whole business. Ibig sabihin, kapag stockholder ka, hindi ikaw lagi ang susunod. Okay? So, we have the board of directors. So, let's talk about naman the nationality of. So, pag-usapan natin pala, try natin versusin yung mga pinag-usapan natin na medias like the corporation, the partnership, liability, limited liability. Okay. So, meron kasing distinction between corporation at saka sa sole proprietorship. Sa korporasyon, the control belongs to the board of directors. Again, sa corporation, ang control, ang pagmamanage ay sa board of directors. Meron siyang limited liability on the part of the shareholders. On the contrary naman, ang owner ng sole proprietorship naman is in the command. Siya ang bahala sa whole business tsaka and stand to lose much ng mga binigay niya or ininvest niya kapag nalugi po ang isang negosyo. Ang distinction between corporation and what do you call this? Ang distinction ng corporation and partnership meron as a legal capacity. Ang korporasyon, meron siyang strong legal personality enabling it to continue despite ng kamatayan, insolvency, withdrawal ng mga nag-share or nag-shareholders or mga members. And sa partnership naman, ang withdrawal or death or insolvency of any partners would automatically bring about the dissolution of partnership. So sa korporasyon, kahit mamatay ka or meron kang issue, tuloy pa rin. Sa partnership, at saka mas madali, di ba? Sabi natin kanina sa korporasyon, pre-transferability of units of investments. Unlike sa partnership, pag namatay ka, may karoon ka ng issue, again, mawawalang bisa po ang isang partnership. Sa limited liability naman natin, it is main feature lamang niya in corporate setting whereas partners are liable personally for partnership sa mga utang niya. Ibig sabihin nito, kapag iisa kayo, ibig sabihin utang ng isa, utang niyo rin. Okay? So generally, every partner is an agent of the partnership. And by this whole act, it can bind the partnership. So, meron din sa topic dito yung nationality of the corporation. So, there are two tests to identify yung nationality ng isang korporasyon. These are the place of incorporation test and the control test. Okay, so the place incorporation test, ito yung mga principal doctrine na kung saan tinitest na ang nationality ng isang korporasyon sa Pilipinas. It actually adheres to the belief that the corporation is a nationality test of the country under whose law it has been organized and registered. Meaning, or on the other hand, pag sinabi natin na control test, it adheres that the nationality of the corporation is determined by the nationality of the majority of the stockholders on whom the control is vested. So sa classification naman ng a corporation natin, a corporation in relation to the state may be classified in the following. So we have the public, we have the private, and we have the quasi-public corporation. And also we have the domestic corporation and the foreign corporation. So ito po yung wala sa module natin na kailangan nating malaman. So we actually have the they call this classification ng corporation according to relations sa state natin. Wala po ito sa module. So kindly sulat-sulat na lang sa gilid. So we have first the public, the private, the quasi-public corporation. When we say public corporation, ang public corporation po are those formed or na-organize po ito para sa government ng position ng estado. Example po dito yung mga municipality or for government function natin. And when we say naman the private corporation, ang private corporation po are those formed for some private purpose like meron silang mga benefits at the end. Like for example, the ABS, the Jollibee Food Corporation, San Miguel Corporation. And when we say the quasi or QUASI public corporation, ito yung mga cross between a private corporation and a public corporation. Example po dito yung mga school district natin, water district, electricity district, and PLDT natin. So according to the place where where they were incorporated. So we have there the domestic and the foreign corporation. So corporation again can be classified as the whole place as to the place where they were incorporated to wit domestic or the foreign corporation. When we say domestic corporation incorporated under the Philippine law. And when we say naman the foreign corporation, incorporated siya, hindi lamang siya, license siya ng Securities of Exchange Commission to do business in the Philippines. Na ibig sabihin po nito, pwedeng mga negosyante ay galing sa ibang mga bansa. Ang foreign corporation kasi, again, license siya ng SEC. And of course, after securing ng Certificate of Authority from the Board of Investments, under ito ng EO of 226, or the Omnibus Election Code, and after complying with condition for issuance of license or application form, is structural organization and capitalization. So let's classify naman according to stock or the let's classify of the classification of corporation as to stock. So stock corporation, we have two: stock corporation and non-stock corporation. When we say stock corporation, ang stock corporation po, private corporation siya which have capital stock divided into shares, and stakeholder or stockholders are entitled to their shares of dividend or allotment of corporate surplus profits based on their stock holdings and subscription. And when we say non-stock corporation naman, these are corporation which do not issue stock and are composed of member, not stockholders. They may be civic, charitable, religious, and of course, professional of the organization. Okay, now let's talk about the other kind of corporation. Okay, for this part, I'll be sending or mag-i-input ako ng link para sa tawag dito, other video, supplemental videos natin sa kinds of corporation dito po. So, let's move. Kasi guys, pag inisa-isa natin to, actually, na-summarize naman na siya sa mga, eto. Okay? Let's talk about the power of doctrines. Sorry. So, dito, meron na natin nagpasan, sorry. Okay. So, the power of corporation, to be honest, can either be expressed or implied. The power is expressed in a if the corporation can perform functions as stipulated by the laws. So yes, nawawala ko ng hininga. So corporation code and such as other statutes pertinent to the corporation in implied power, the power is inherently necessary in the exercise of its corporate function in the pursuit of its corporate existence. So the doctrine of piercing the veil of corporate existence, it is a general principle under the law that a corporation has the personality which is separated and distinct from its member. However, the said principle would not apply to some instances, and as held in the case of San Juan Structured and Steel Fabrication Inc. versus the Court of Appeals. So kindly search for that case, the San Juan Structural and Steel Fabrication Inc. versus the Court of Appeals. So the trust fund doctrine naman, so when we say doctrine of business opportunity, so this doctrine refers to the case when a director or officer of the corporation is presented with a business venture which can have profitability handled by the corporation. He must give that business opportunity to a corporation, and he also shall be held liable to refund to the corporation whatever profits and benefits he may have derived from such business opportunities. The trust fund doctrine, when the directors of the solvent or insolvent corporation distribute all corporate assets to the stockholders without reserving any assets for payment of corporate debts and liabilities. The directors or officers, together with the stockholders who have received the assets, are considered trustees, and the corporation and the creditors can recover from the stockholders such as the corporate assets they received shall be sold at the public auction for the settlement of the corporate liabilities. So, ang distinct between corporators and incorporators. So, when we say corporators, ala po sa module nyo to ha, when we say corporators, these are the these are the total number of persons who compose the corporation after its formation, which include the incorporators, the stockholders, or the members. And when we say incorporators or stock or non-stock, they must be natural person, totoong tao. A juridical person cannot be incorporator. The law provides the incorporator must be at least 5 but not more than 15. So, paano po natin siya ma-align sa industry na meron po tayo? So, the registration ng requirements ng isang establishment business pertinent sa ating industry. So, ang promotion ng different tourist destinations sa isang bansa may be well settled na through the opening of various businesses, well supported ng mga respective local government natin or LGU natin, with the coordination or collaborating with the Department of Tourism ng bansa natin. So in the making, ang said mandate possible, the regulatory power of state through licensing of business may be used, especially sa corporation natin. In this regard, the public in general, local man siya or foreign tourists natin, may be assured the quality service from the hospitality industry, and it can actually affect an addictive of the tourist attraction natin. So, again, to summarize po natin kung ano nga ba ang ang corporation again. Ang corporation natin ay when we say corporation, ito ay isang artificial being created by operation of law, having the right succession of powers, attributes, properties, etc. And again, meron siyang mga advantages. We have, of course, a strong legal personality, limited liability to investors, pre-transferability of units investment like pag namatay or transfer, centralized management, and also, meron po tayong mga tinatawag na distinct between corporation and partnership as to legal capacity, yung mga iba-iba niya. Incorporation, partnership, and limited liability. And also, it actually has the nationality of the corporation. So, we have the place of incorporation test and the control test. Diba, pag sinabi natin na place of incorporation test, doctrine test po siya, nationality of corporation sa Pilipinas. Ang control test naman, They-define po ito yung majority ng isang stake o stockholders, kung sinong pinakamadami. And of course, we also have the classification sa relation. We have the public, the private, and the quasi. Pag public, ito yung mga municipality. Kapag private naman, meron siyang in return, meron siyang benefit sa dulo. Ang quasi naman, between siya ng public and private. So we have the qualification ng place ng incorporation. We have the domestic and the foreign. Pag domestic, Philippine law naman. Pag domestic naman, kailangan issued or licensed po tayo under the the SEC. Okay?